When a hearing is over, judges may decide a change must be made. However, they don't say exactly what the new rules should be. NGOs and campaigners can make a real impact on the lives of the people they work with by making their voices heard in the formation of new policy and practice post-litigation. This is the vital embedding phase, which can ensure that the change is long-term and lasting. In 2015, a case came to the UK Supreme Court regarding the removal of access to student finance for young people who were legally resident in the UK but not yet citizens. Just for Kids Law were a third-party intervener and brought the voices of many other young people in the same situation to the court. Tigere won her case. Fantastic, right? But after the court's decision, there was more hard work to be done.
There's often a lot more work to do once the case is finished. You really need to make sure that any changes that come about because of a judgment are really followed up on and are embedded in law and policy and practice so that the people that you're working for really feel those changes on the ground.
When we left out of court, the court was clear that the regime that currently existed was no longer good enough. But what they didn't say is what the new regime should look like. And so we had to work really hard to make sure the new regime was the best one that we could possibly get. And that involved quite a lot of lobbying and working in conjunction with other parts of civil society.
The Tigere case was a win, but it was a partial win, and some people still weren't going to be able to go to university because they wouldn't have been able to meet the rules and regulations around it still.
After the judgment, the Department for Business, Innovation and Skills drafted an interim policy. Just for Kids Law and other organisations thought that it didn't go far enough to help all the people that it could. Just for Kids Law, other organisations and the young people involved went to BIS to ask for a fairer policy.
Because it was such a personal issue, and I knew that someone sitting in front of me could make that change. So that sort of was just an inspiring moment. And then I didn't fear of anything and just shared my story as powerfully as I could.
Because I wasn't speaking for just myself, I was speaking for the entire migrant community who wanted to go to university. So it felt like a lot of pressure. And when I got there, I couldn't help but break down.
The final guidance that has come out. And in fact, they acknowledged in that they were persuaded by some of the situations put forward by civil society.
At the same time as the interim policy issue, student finance bodies were not changing the information they were giving young people, even those to whom the ruling did apply.
Student finance was not giving accurate advice to people about what their situations were. That led to quite a lot of other offshoot litigations as well for individual students.
Another huge area of work was managing hundreds of inquiries from young people in similar situations who contacted Just for Kids Law after the Tigere case to understand their options.
After the case, we had an influx of calls to the client inquiry line that we have. And so it was young people wanting to figure out how this new rule would affect them, when the new law would be in place, because some people think that after the judgment it's immediately changed.
Often there'll be a lot of media attention around a legal case, and if the organization gets a mention, they'll probably get loads and loads of calls from people who are in similar situations. And that happened with the Tigere case.
A lot of people, specifically in my own school, who I didn't know had been through that same situation, were contacting me on Facebook, on Snapchat, Dammy, I'm also in this situation, is there any way I can get any help?
However, these hundreds of inquiries enabled a movement to grow. The young people who had been affected by the previous rules organised themselves into a campaign called Let Us Learn. The Supreme Court judgment gave Let Us Learn a focal point and a big energy boost.
One of the brilliant things that come out of it is this creation of this very strong movement of young people who are now committed activists and committed to social change for young people in their situation and others across society. And we've really invested a lot of resources into making Let Us Learn grow.
Post-judgment, I think it's really important to share more information with the young people so that there's absolute clarity in what we're going to do moving forward. So you can really back up the legal side with the organising and mobilising young people.
We have a monthly gathering at Let Us Learn, and that monthly gathering, a young person will get up and tell their story, and we'll do a lot of prep work with them.
We go to schools, we share our stories with people in year 10, 11, in college as well.
We did the Young Gifted and Block campaign, and that is an amazing campaign because, again, we saw young people gather together to go to universities and say, you need to help us, you need to allow us in.
I think the movement was able to grow because of the fact that we had a good understanding of what it meant, and we were able to draw in other young people with sharing that information.
It was a kind of a momentous event for them to be a part of changing the law, because that feels so impossible, especially when you're young, and to be a part of that and to know that because of their engagement and involvement, a lot of their group and others would be able to go to university was an extraordinary experience.
Just for Kids Law and Let Us Learn kind of gave me hope and kind of gave me this sense of I can do something about this situation.
It's us being involved from the very beginning, from the planning to the execution of it all. And so we've created almost a mini family, and so we've provided a hub of support.
Knowledge of the change needs to be spread to the people affected and the professionals who work with them. Resources must be available to answer a potential influx of inquiries. Policymakers must be persuaded to implement the change in the best way, and the energy created by the court case needs to be harnessed. But by doing all this, you could change more than just the law.